Good afternoon, everyone. My name is Jim Hagen, and I'm speaking to you from lovely and glorious Discovery Bay. I've been involved in land use and shoreline planning issues for about 4 years. I'm a member of the Citizens Alliance for Property Rights and was a former chairman of the Planning Commission. So I'm here today to speak to you on what is about to be a huge change in how these beautiful shorelines that you see before you are going to be used. Jefferson County citizens have a long history of excellent stewardship of the land. In fact, it's been a well-documented fact that the people in Jefferson have taken about the best care of their shorelines of anywhere in Puget Sound. But despite that, the Department of Ecology and Jefferson County are on the verge of passing drastic new regulations that will completely and dramatically change how you are going to be able to use the shoreline immediately and have consequences for how your heirs may be able to use the property that you have worked so hard for and which represent all of your dreams and wishes. We're nearing the end of a long 4-year process, and on May 11th, the current public comment period in which citizens can express their support or their objections to these new proposed regulations, the deadline will be May 11th. I cannot emphasize enough the consequences that these new rules will have on how you use your shoreline properties. The current 30-foot setbacks are intended to be replaced with 150-foot buffers, which combined with a 10-foot building setback make up nearly 3/4 of the shoreline jurisdiction, that being from the high tide mark to 200 feet inland. So what that really does is that converts nearly 3/4 of this shoreline area into a buffer zone, 80% of which is going to be a no-touch area. Along with that are going to be vastly increased restrictions on common accessory shoreline uses such as beach access, boats, boating facilities, docks, piers, mooring buoys, and so on and so forth. Nearly half of the shoreline has been reclassified as natural, which means any use at all, including the building of a single-family home, which is currently and always has been a preferred use under the Shoreline Management Act, is going to require a conditional use permit, which means oversight by the Department of Ecology. And many other common accessory uses, such as beach access and, most important, bulkhead and armoring to protect your home from erosion, are going to be prohibited. But most significantly, one of the biggest impacts of these new regulations will be that any existing homes that are located inside of that new proposed 150-foot buffer are going to be called a non-conforming legal use. And while the Department of Ecology and the county has assured us that non-conforming uses are going to be protected and it's really not going to affect how you use your property, if you really read the fine points, you'll find that that is not true. Washington courts have ruled that non-conforming uses are disfavored by the law and are eventually to be phased out. The Department of Ecology has itself published a PowerPoint presentation in which one of its slides, it said that non-conforming uses, the goal of non-conforming uses is to eliminate them. During the process for deliberation of these new proposals, one of the commissioners talked to somebody from the the MRSC, and asked for some advice on the impact of non-conforming uses. And again, the Commissioner Austin was referred to the same PowerPoint presentation and the same person who authored that, Betty Renker from the Department of Ecology, which said that yes, non-conforming uses are disfavored by Washington law and are eventually to be phased out. The Department of Ecology said that those characterizations are taken out of context and so on and so forth, but if so, why do they keep popping up? And if Department of Ecology really wants to reassure people that their existing uses are going to be protected in perpetuity, then they can restructure the regulations so that they are not made non-conforming. There's a very simple solution here. The powers that be, Jefferson County Department of Community Development, and the Department of Ecology have really put a rosy spin on how good these new regulations are going to be for us. And they have told us that they are very balanced to include protection of the environment and protection of private property rights. But their actions have in no way reflected that balance. And at the public hearing just last Tuesday, before public comment was opened, Jeffrey Stewart, the Department of Ecology Shoreline manager, gave a presentation, and included in that presentation was a PowerPoint presentation again that was accompanied by pictures that depicted the environment in this beautiful, glorious, pristine, almost spiritual manner. And then when they showed the shoreline uses by humans, where houses were present, that use was depicted in a very negative manner, that it was going to be inherently harmful and automatically damaging to the shoreline. The example that the Department of Ecology used as an example of a non-conforming structure was in fact a dilapidated old, broken down old shack on stilts, which is no way representative of the typical home on Jefferson County, which is lovingly cared for. And again, which represents the dreams of all the blood, sweat, and tears of everything that people have worked for, of families raised there, of families growing up who in turn have their own kids who come and meet for holidays and so forth. I mean, who in their right mind is going to not take care of their homes? And what's worse, who in their right mind would even insinuate that people would not treat their land in a manner any other than what would be the most loving and caring way? So this is really, that depiction, a picture is worth 1,000 words. And that says a lot about what the ecology thinks about the human presence on the landscape. Another thing that's really been troubling is in the development of these rules, public participation is not only valued and representative of our constitutional democracy, it's also required by law. And throughout this whole process, the Jefferson County Department of Community Development has continually characterized any objections by citizens to these new rules as misinformed, as being myths, and downright untruthful, creating hysteria. This really speaks ill of the attitude that our public servants hold towards the citizens that they basically serve. And in fact,